today we're going to talk about subcontracts. Going to talk about subcontract reviews, what should be included, how many to look at, and when. So let's get started on that. Now, everything we are talking about today revolves around this single principle, and that is that no work can be done on the project by the prime, a sub, or a supplier without an executed agreement in place. So all firms working on a CDOT project must have an executed agreement to work on the project, and they must be approved by CDOT to do so. So that is our core principle. Everything we're talking about works around this statement today, okay? Now, FHWA 1273, Part 6, Section 4 says that no portion of the contract shall be sublet except with the written consent of the contract officer, which in this case is CDOT. All right, and to obtain approval by CDOT to work on the project, the prime must submit a Form 205 request into B2G for all lower tier subs. Remember, we've talked about this in several of our other series. It's the prime contractor who is submitting that request, even for second, third, or fourth tiers, okay? Now, suppliers over $10,000, they use the 1425 to submit into B2G for that request, and both must have approval by CDOT. Now, Section D of the Form 205 clearly states that by submitting this sublet permit application, right, when they make that request into B2G, when they attach that 205, the prime contractor is certifying that the contractor has personal knowledge that an executed subcontract or service agreement for the work or supplies that are being requested is in place and includes all of the required FHWA provisions. So at that point, they're saying it's been executed, it's there, it's got all the required provisions. That's what that prime contractor is saying to CDOT when that request is submitted. It further says that the subcontractor shall not commence work until the CDOT engineer approves the sublet permit application, and the contractor shall be responsible for compliance by any subcontractor, lower tier sub, or service provider, okay? So that's what it's saying when they submit that request. This is huge because, you know, there's been times after that sublet has been submitted and it's been approved that then the subcontract is requested. And guess what? They're saying that it doesn't exist, and that's not okay. So let's take a look at roles and responsibilities. We try to do that in all of our sessions so that everyone understands what role they're playing when we're talking about these different workflows throughout these sessions. Now, the prime or subprime enters into a contract agreement for work, services, or supplies with lower tier subs or suppliers. And it is that upper tier contractor's responsibility to include these federal provisions that we're talking about today. It is the prime contractor's responsibility to ensure that the subcontracts contain the required provisions and then submit the request for approval to CDOT via B2G. So that upper tier subprime is the one executing the agreement, and they're supposed to make sure those provisions are in there. But that responsibility also falls on the prime contractor, who's ultimately responsible for the project and making the requests through B2G. Now, the project engineer, remember, CDOT uses project engineer globally. It refers to, could be internal CDOT staff. It could be a consultant doing the oversight. It could be local agency, whoever's responsible for that oversight function. The project engineer then approves the request to sublet and also spot checks subcontract agreements to ensure the federal provisions were included as per the affirmation statement made by the prime contractor. So when we say federal provisions, you know, what are we talking about? Well, we're talking about FHWA 1273 and the prevailing wage decisions. And to date, we've talked about these two documents a whole bunch throughout our various trainings, and CDOT talks about them all the time in their regular trainings as well too. But we're going to dissect it a little bit more today. Let's first look at FHWA 1273. Now, 1273 is a fabulous document. And the reason why is because Federal Highway has done really all the heavy lifting for us and gathered up all the civil rights requirements and packaged them into this nice little document for you. So it's super easy to say, hey, you need to have FHWA 1273 attached to the subcontract. And guess what? It's going to have all those various provisions that apply bundled into one nice document. And I can tell you, if you've done very much work with FAA or FTA, they don't have a document like this. So this is so nice. Now, part 1 of FHWA 1273 tells us to do just that. It tells us that we've got to put 1273 in there. It says 1273 must be physically incorporated in each construction contract funded under Title 23 United States Code as required by 23 CFR 633.102B, right? It's telling us that. It's saying that the contractor must insert this form in each subcontract and further require its inclusion in all lower tier subcontracts. Now, it does say that this excludes purchase order, rental agreements, and other agreements for supplies or services, and we're going to talk about that here in just a second. In that second paragraph, we're talking the first page here of 1273, right? First paragraph says you got to have it physically incorporated. It's got to be inserted. And then the second paragraph says that for work done under purchase orders, rental agreements, or agreements for other services, that 1273 is incorporated by reference only, okay? So subcontract, we've got to have it physically incorporated and attached. For purchase orders, rental agreements, or agreements for other services, by reference only, okay? Now, what else does it say? We've also got this third paragraph that talks about design build contracts. We probably don't have a lot of design build contracts in the local agency program. I know that there are a few, but it says 1273 for design build contracts, 1273 must be included in all subcontracts and in lower subcontracts. But then this section excludes subcontracts for design services, purchase orders, rental agreements, and other agreements for supplies or services. Now, when it does this, this often causes confusion for recipients that have design build contracts, because then it says, because it says excluding these contracts. But that's not true, because paragraph 2 still stands alone and applies, which says it has to be included in there by reference, okay? So don't get confused by that. Paragraph 2 is a standalone paragraph and must be applied. FHWA 1273 also states that the prevailing wage determinations applicable to the project must be attached to the subcontract. This is stated over in Part 4, Section 1 for minimum wages. It says that all laborers and mechanics working upon the site of work shall be paid at rates not less than those contained in the wage determinations of USDOL, which is attached hereto and made a part hereof. So in summary, for subcontracts, 1273 and prevailing wage decisions must be physically incorporated and attached, right? For purchase orders, rental agreements, and other agreements for supplies and services, 1273 must be included by reference. Now, for prevailing wage decisions, if they apply, they're going to be attached, right? And they're going to be made a part of that document. So let's talk about some of these terms. First, we've got physically incorporated. By definition, this means to incorporate is to include or integrate a part into the whole. So when you read that agreement, the document itself must embody 1273. It must be made a part of the legally binding agreement. Inserted to, we've heard that phrase. This means to put something inside something else. Therefore, the document must be inserted or attached, right? Now, it tells us to insert 1273. And when the regs tell us to insert 1273, that means all 13 pages must be inserted into the subcontract. You can't cherry pick 1 or 2 of them. Okay, we're going to talk about that a little bit more, about some examples on that. And the wage decisions must be attached. Well, this means joined, fastened, or connected to something. All right, we're going to dissect that a little bit more here in a minute. So when we're looking at these agreements, what should we be looking for? Well, first of all, we want to make sure we've got an executed agreement, that the agreement is between the correct legal parties, those being approved by CDOT. If it's a subcontract, that 1273 has been physically incorporated and attached in its entirety. If it's a PO, rental agreement, or other services agreement, that 1273 is referenced. And if the work is subject to prevailing wage decisions, that the wage decisions are included and attached. Now, what if you don't know what applies? Well, then you should refer to the prime contract and confirm the prevailing provisions. Or if you're the local agency setting up the prime contract, then refer to your intergovernmental agreement with CDOT, the IGA, and the local agency manual. Now, as a general rule of thumb, if a provision is included in a contract and the provision doesn't apply, it's okay. We see this happen a lot. We see it happen a lot with local agencies, especially when local agencies are getting a lot of different types of funding. Sometimes they aren't sure. And so we'll see 1273 sometimes inserted into, FAA funding and what have you. It's okay. It's not the end of the world. And typically you want to work with CDOT, if you're not sure about that, to make sure you're getting the right provision, especially 1273 FHWA funding. The issue is more so when a provision applies and it hasn't been inserted. So a lot of times this is why we see, provisions just being put into a variety of documents. But your local agency manual has really dissected this for you. You've got your regions to reach out to. They'll take a look at those subcontracts or those prime contracts, and then the subcontracts will follow suit from there. Okay. Now let's look at this a little closer. When reviewing a contract agreement, the first thing you want to make sure is that you've been provided a copy of an executed agreement. This means that both parties have signed the agreement and it clearly states that it has an executed date. I've had this happen, I don't know how many times. I'll request a subcontract and I get one that nobody has signed or that only one of the two parties has signed. Send it back. Tell them you need an executed agreement. Otherwise, what's the point of looking at it if it's not the final executed document, right? Now, there are different ways that the contract document may identify an effective date, and this is just kind of basic, contract law. The agreement may say it clearly. Many times this will be like the first line of the contract, and it might say, we've just given you an example here. This agreement is hereby effective as of this day of this month, year, between such and such parties, right? It might also be that the contract is effective as of the date of the last signature of the two parties. If so, it's going to say that. So make sure, when is the contract effective? Okay. One, you got executed agreement, and when did it become effective? If you can't tell when that agreement became effective, you need to be asking some more questions, because maybe it isn't actually executed. Okay. But typically it will tell you. Now, secondly, it's important to determine that the contract you are reviewing pertains to the subcontracting relationship at hand that was approved in B2G, right? You want to be sure to compare the parties of the agreement to the subcontractor approval request in B2G, as well as the Form 205 or 1425 that was attached. It should all read the same parties. If it doesn't, you need to start asking questions. Next, we need to make sure that 1273 is physically incorporated. The contract document should clearly state the provision and its attachment. So we've shown you some example wording here. For example, FHWA 1273 is hereby made a part of this agreement and attached hereto as Exhibit A. Now, sometimes I've seen it where 1273 is like a list of several provisions that apply. So it's one of the bullet points that are attached, and that's okay so long as 1273 is named and its location is clearly stated in the document and referenced. Like they're probably going to line all of those up in an attachment or an exhibit of some sort, and it needs to be referenced as such. That way it's clearly stated where it's attached, because remember, 1273, that's a requirement. Now, it is not acceptable for 1273 to merely be added to the back of a contract document with no reference to the provision or where it lives within the contract itself, right? Because remember, the whole point here is that these requirements need to be made a part of the legally binding agreement, and they must be physically incorporated and attached. Now, when you request a subcontract, more than likely in today's time, you're going to get some sort of electronic PDF file. And we've often seen where the subprom may have forgotten to include the federal provisions and then realized that when we requested the subcontract. So they may have just at the last minute added the pages of 1273 to the back of the PDF document that was transmitted with no incorporation of inclusion of the actual attachment. This is not acceptable. Okay. Think of it like this. Think of it of if you were to print that document that you got in a PDF and you just threw it all up in the air, right? Just scattered the pages everywhere. Would you be able to put it back together? And would you know at that point that 1273 was a legal part of that document? If not, then the document more than likely has not been physically incorporated and attached. So we're not looking for pages of 1273 just randomly attached to a PDF, okay? It must be physically incorporated and made a part of the agreement. Now, again, for purchase orders, rental agreements, and other service agreements, 1273 may be included by reference only. An example of wording you might see is FHWA 1273 is hereby made a part of this agreement. Now, another thing I've seen, remember I mentioned before that sometimes they'll include this in a list with a lot of other provisions. And sometimes you have to kind of follow the trail. Like they may say, Exhibit A, the federal provisions in Exhibit A are hereby made a part of this agreement. And then you go to Exhibit A and it lists all of those. Is that okay? You know, if it's saying Exhibit A is hereby made a part, and the reference documents, and that's above the signature line, it is. So if you can follow the trail to it, yes, every contract is set up differently. But if you have any questions, reach out to your region, reach out to us. We'll certainly help you with it. Now, prevailing wage decisions, those must be attached in full and referenced as an attachment. Again, same just like with 1273, which this means they must be made a legal part of that document, not just merely attached. Okay, and we've given you some example verbiage here. So what happens if you review an agreement and it doesn't contain the correct provisions? We've told you this in other trainings. We're going to tell you again, the agreement must be corrected immediately. You can do this by way of a $0 change order or amendment, whatever they want to call it, that then makes that amendment or change order a part of the original agreement and thereby incorporates those federal provisions. Now that amendment's got to have them attached too, right? So they've got to be physically incorporated and made a part of and attached. But the amendment can do that. It's just a $0 amendment. So when we say the subcontracts must be reviewed, what does that mean from a quantity and timing standpoint? Well, there's no specific required percentage, but the Civil Rights Office at CDOT does feel that a best practice and reasonable approach is to look at 20% of those executed agreements. And this would be 20% of all those subcontracts and suppliers that have been approved by CDOT to work on the project, right? So if, for example, if to date I've got a total of 20 subs and suppliers that have been approved on the project, then looking at 20% means that I would have looked at 4 of those agreements, and that would be recommended. Now, for frequency, it is recommended to review subcontracts sooner rather than later, right? It doesn't really do you any good to review subcontracts at the very end of the project because those subcontracts is what everybody's been working in accordance with, right? So typically what we do is, you know, we kind of have a rolling calculation and we always make sure that we're looking at at least 20% as subcontractors are getting added and approved. Now, is 20% just hard and fast? No, like I said, this is a risk-based approach. So, you know, it's okay to look at more, especially if you've got red flags or if you're seeing that every subcontract you look at doesn't have any of the federal provisions. This is why it's super important to look at those on the front end of the project, because as they're bringing on subs, You know, they may have like a blanket document for a subcontract agreement, and that's the one they're using for everybody. So chances are, especially if it's the first tier, that whatever document was used by that particular prime or subprime, probably you're going to see those same issues across the board, right? So it's really important to get on the front end, make sure everybody's clear about what has to be included so that you don't have a compounding effect across all of those subcontracts. But there's nothing wrong with looking at more. It's great to look at DBE subcontracts too, right? Because that's going to further support the 1415s and the utilization plan that was submitted. And also those 1432s as they're coming in. So let's test our knowledge just a little bit. Here we've got a question, and you're welcome to throw it into the chat box what you think the answer is. If FHWA 1273 and the prevailing wage decisions were not included in a lower tier subcontract on a federal aid project, what action should the local agency take? And this can be globally. What action should the project engineer take, right? A is get a verbal commitment from the sub that they will comply with the federal provisions. B, require the upper tier contractor to issue a change order to the original subcontract and incorporate and attach the FHWA 1273 and prevailing wage decisions. C, tell region and let them worry about it, let them take care of it. Or D, require the prime contractor to provide a statement of their commitment to monitoring the subcontractor's compliance with the required provisions. So I have no doubt that all of you got this right. It's B. They're going to need to get an amendment and modify that original agreement to physically incorporate and attach those documents, okay? And we're talking about all pages of those documents. So let's try another one. If when reviewing a subcontract, the reviewer notices that not all of the pages of the wage decisions were attached, is this acceptable? The answer is no. Okay. We're going to take some questions, fill some questions. If we didn't particularly hit on your scenario, we've got our contact points here that you're welcome to reach out to, as well as the your region. And so we'll hop over to some questions and answers here at this point now, okay? Okay, so it says here, what if the amount on the subcontract agreement is different than the 205 or 1425? Then they'll need to submit a new 205 1425. Now, let me clarify this too. It could have changed, right? So if the original, let's say that by the time you look at the subcontract, if it's the original subcontract, then what they submitted on the 205 should have agreed, right? If it doesn't, let's say they've issued a change order since then, they should submit a request to notify you of increased dollar amounts. And at that point, if there's increased dollar amounts on a subcontract, the prime contractor can't actually enter that in B2G. There'll have to be a notification given to the project engineer or whoever's doing the oversight. They then, or the region, can actually go in and update that agreement amount. This is particularly important if it's a DBE, right, for tracking DBE participation. And just a reminder too, then, that the subcontracts can actually be attached to that contractual relationship that's been approved in B2G, so that those documents are there, contained there.